William Ruto, and we're assisted by our case manager, who is Judy Mionki, who sits at the end of the row here. Before I sit down, can I just thank the court for its expression of condolences in respect of the death yesterday of Mr. George Satoti, the Minister of Security in Kenya, together with the 5 others who accompanied him in the helicopter. He was a colleague of Mr. Ruto, a potential witness in this case, in fact, and obviously a loss to the Kenyan people. May I also express, generally on behalf of the defence, our regrets and concern at learning of the detention of Melinda Taylor and others in Libya in the course of their work, and we hope that that is speedily resolved. Thank you.
Thank you very much, Mr. Hooper, and thank you very much for the kind words for the court. Defense team for Mr. Sam, please.
Your Honours, my name is Katwa Kigen. I am counsel for Mr. Sang, and together with me is Mr. Sang himself, Logan Humbrick, Kimtai Pasek, and Philemon Koech. Thank you, my lord.
Thank you very much. Legal representative of victims?
May it please your Honours. My name is Soretta Chana, and I represent 327 victims. Well, in fact, it is now 326 victims because one victim died on 24th March 2012, sorry. I'm assisted by my case manager, Ms. Mariana Penna. Thank you.
Thank you very much. Registry team, please.
Bonjour, Madame le Président.
Good morning, Your Honours. Today, for the registry, I'm here, Charlotte Dahuron, Court Management Service, Peter van der Debrecht, Legal Coordinator, and Jakdula Ideva, who is representing VWU.
Thank you very much. At today's status conference, the charges will not be read to the accused, but pursuant to Article 64(8)(a), this will be done at the commencement of the trial on the merits. Now let's go into the agenda items of this status conference. First of all, start date of trial. According to Rule 132, the trial chamber must set the date of trial. The prosecution submits that the start date of the trial depends on, and I quote, the court's ability to protect witnesses as well as cooperation with the court's process by the accused and the government of Kenya, unquote. Apart from the protection of witnesses, the prosecution does not identify any other facts that could delay the commencement of trial. Now, questions to the prosecution. First, can the chamber assume that the prosecution is ready for trial and that fulfilling disclosure obligations and lifting reductions are the only actions that it needs to take at this stage? And question number 2, can you explain how much time you anticipate will be required to resolve any witness protection issues in order to be ready for trial?
Your Honor, in answer to your first question, we have a pool of witnesses that we are interviewing. There's important protection issues involving the selection of witnesses, and we'll go into that in more details this afternoon. Regarding the date of trial, in answer to the defense's submission, Rule 132 applies, and according to such, it is for the trial chamber to set the trial date regardless of the dates of elections. Both defense teams have submitted that trial date should be for March 2013. The prosecution has no objection to setting the trial date at such time. However, if it is set at such time, we would ask that a written undertaking from the accused be produced so that regardless of the results of the elections, they would appear for trial. And regarding the disclosure position taken by the defense, which is to have all of the prosecution's material disclosed 4 months before the beginning of trial, the prosecution objects to having such a large time between the end of disclosure and the beginning of trial for protection issues that we'll go into when we discuss disclosure in more details and protection issues this afternoon.
Thank you very much. One clarification. Prosecution mentioned that prosecution is still interviewing witnesses. What could it mean? I presume, the chamber presume that at this point, after several months since confirmation of charges, prosecution has already completed its investigation?
Your Honor, the prosecution still has the same witnesses that we had at the confirmation hearing. However, because of the situation in Kenya and because of specific incidents in relation to some of these witnesses, we are in the process of interviewing other witnesses at this stage, and we will discuss these issues further this afternoon.
Thank you very much. Well, before hearing responses from the defense on this issue of trial date, the chamber would like to address related agenda items, which prosecution also mentioned right now, namely disclosure and reductions. The prosecution already in its written submission has indicated that due to witness security concerns, some incriminatory material has not yet been disclosed to the defense, and that the disclosure of the remainder of this evidence depends on the final selection of witnesses. As for the selection of witnesses, the Chamber will set a deadline for the prosecution to file its final witness list in due course. As for the disclosure of incriminatory material, the prosecution just mentioned that 4 months before the start of the trial is too early. But considering also the substantive preparation on the part of the prosecution for the trial, by what date does prosecution anticipate being able to complete the disclosure of incriminatory material?
With your permission, Your Honor, I'm conferring with my colleagues. Thank you. In answer to your question, Your Honor,
Yes, please.
the prosecution will be able to finalize disclosure in the first quarter of next year.
Okay. Well, concerning reductions to the identities of witnesses who will testify at trial, the prosecution has also suggested that a staged approach should apply to the lifting of reductions to the identities of testifying witnesses. In its filing 417, paragraphs 16 and 17. For those witnesses who are part of the court's protection program, it is proposed that reductions should be lifted 60 days before the start of trial, whereas reductions to the identities of testifying witnesses who are not part of the court's protection program would be lifted 30 days before the start of trial, and or in exceptional circumstances 30 days before the start of the witness's testimony. Now, question for both defense teams. How do you react to this suggestion by the prosecution?
Dealing with item C on your agenda, Madam President, on behalf of William Ruto, our reaction is that we don't object to the prosecution's proposal that the identity of witnesses who fall into the category of witnesses who are part of the court's protection program should be lifted in principle only 60 days before the start of the trial. However, as with the other categories, we hope that the prosecution could see their way with some of the witnesses to revealing identity earlier than that. Secondly, in respect of those witnesses testifying who are not part of the court's protection program, the prosecution have asked that, in principle, their identities should be not revealed until 30 days before the start of trial. And again, the defence has no objection to that, and again, subject to the same caveat as I've just expressed. And then we come to an exceptional situation where, as the prosecution express it, where it's justified by security concerns particular to an individual witness, that the prosecution should be permitted to make an application to the Chamber for the witness's identity to be disclosed 30 days prior to the start of his or her testimony. We would stress, first of all, that such a situation should be wholly exceptional. Secondly, we're concerned at the limit of 30 days. We think it should be, at the very least, almost 45 days before the start of such an exceptional witness's testimony. And part of the reason for that is that, of course, when you're in trial, you've got fewer facilities to dedicate to investigation and matters like that, so it interferes with the work that you're doing during the process of the trial. And one of the general matters that needs to be taken into account when assessing a prosecution application of that kind is the significance of the witness and the witness's relationship with other witnesses, because a witness doesn't stand in isolation, and unless you know the identity of a witness, it's difficult, in fact, to perhaps cross-examine other witnesses and question other witnesses about facts and the personality of the witness whose identity is being withheld. And finally, in respect of this issue of identity of witnesses, it is, of course, a much larger feature than just the name of the person. All the redactions in the case have tended to be redactions that go to identification of the witness, and they have been quite excessive in the pre-trial stage, in the pre-confirmation stage. So, for example, we even have dates of meetings that have been redacted in case the date of the meeting triggers knowledge of the identification of the witness. Apart from the oversensitivity that we feel has been demonstrated in this regard by the prosecution in seeking redactions, we're concerned that the massive redactions that presently exist, which are justified on the basis of otherwise the identity of a witness will be revealed, will be maintained. And we hope they're not maintained to the level that they are at the moment. Because, frankly, we cannot do the investigations that are necessary with the degree of redaction that we presently have. I'm not going to go into individual situations at the moment, and indeed it would be a waste of time because we don't yet know which witnesses the prosecution are going to use in trial. We don't know whether they're going to maintain the witnesses that they presented at confirmation, or whether they're going to abandon those or some of those witnesses, and what new witnesses they might have in mind. There's clearly, from what's been said this morning, a long road for them to go if final disclosure cannot take place until the early part of next year. So our concern is, though this issue of rolling disclosure in principle is acceptable, the extent of it worries us in terms of the extent of redactions that would be the product of that. And that's our only concern. Thank you, Madam President.
Thank you very much, Mr. Hooper. Mr. Kigen-Katwa?
Your Honors, on our part, we have no objection to the first two categories, being the 60 days disclosure prior to the hearing in respect to protected witnesses, and to the 30 days prior to hearing in respect to unprotected witnesses. We will only request that in presentation of that aspect, the prosecution to represent the court as to whether the respective witnesses are comfortable with a disclosure of their identities earlier than those dates, the 60 days and 30 days. And if the witnesses have no objection, we would be happy to have the disclosure made earlier. In respect to the disclosure 30 days to the date of testimony by the respective witnesses, we, in the first instance, adopt entirely the observations made by the team for Mr. Ruto. And in addition, we pray on our part specifically that 30 days is far too short, and we would propose on our part 45 days. Secondly, we pray that the issue of the time within which to make the disclosure should be closely supervised by the court in terms of, first of all, the criteria as to whether or not such witness needs protection up to 30 days before he testifies or otherwise. And secondly, whether the date can be made more elastic and be disclosed earlier than 30 days. We make this observation because the disclosure that was made at the period of the confirmation included reductions on very fundamental issues like the dates of the meetings, which go to the root of the case. And we pray that the fundamentality of some of those reductions be closely supervised by the court. Lastly, we pray that the court do reserve for us the option to apply for an adjournment in the event a disclosure is made in the course of trial that necessitates, number one, an in-depth analysis on our part, and secondly, an investigation of the issues raised. The reason being that if the disclosure is made in the course of the hearing and it is too fundamental, we would need time to analyze it, short of which we would not be able to conduct the hearing without adequate time. And so we would pray that will be an option for us to seek an adjournment be preserved on that aspect. Thank you very much, Your Honors.
Thank you very much, Mr. Keegan-Catwell. Do you want to?
Question for the prosecution, just for my own purposes, to be sure that I understand what you're proposing. When you say witnesses who were not within the protection program of the court, I understand that to be those who are not protected witnesses. If that is my understanding and it is correct, I'd like to understand why unprotected witnesses would need a longer period. Sorry, protected witnesses would need a longer period, have the identities disclosed for a longer period of time than unprotected witnesses. Is that the intention?
Your Honor, in answer to your question, my colleague Laura Renton will respond.
Your Honours, perhaps we weren't clear in our submissions, but the witnesses who don't fall part of the ICCP for whom we would want disclosure 30 days prior to trial are not, for example, witnesses that don't have protection issues. If I could use the example of expert witnesses, for example, we would disclose their identities without any issue. But it's witnesses who still have issues of security and protection, but for whatever reason aren't part of the court's official protection program. So it may be that they didn't want to become a part of the protection program, but there are still concerns between the prosecution and perhaps VWU as to their personal protection. That's why we think there should be a shorter time between the disclosure of their identity and the start of trial. There are, as I said, still protection issues. They're simply not part of the official court's protection program.
Thank you very much. another clarification from the chamber. The prosecution said most likely the prosecution can complete the disclosure of incriminatory material in the first quarter of next year. Do I understand correctly that, well, I have to confess that this time frame is much, what do we say, not as early as we anticipated. Do I understand correctly that the only reason for this delay of disclosure of incriminatory material is protection of witnesses?
Your Honor, the protection of witnesses and the management of witnesses are core reasons for the date set for disclosure. And for these reasons, we are interviewing witnesses in Kenya.
Thank you very much. Another clarification is for prosecution is, can you identify roughly how many witnesses fall in the category of unprotected witnesses who have security issues?
Your Honor, in answer to your question, we cannot estimate at this time the precise number of witnesses that are not subject to non-protection. Thank you.
Madam President, if I may
Yes,
come in here. I think it's important that the court hear the views of the victims in respect to the date of the trial. As I have said in my motion that I haven't been able to consult them of late, and they haven't been able to consult me either, but I do know that the victims' concern is that they want the date of the trial as quickly as possible because it also then impacts on their reparations. A lot of them are not very well, and they also have a perception that in the local courts in Kenya, that delay of proceedings is something which is normally done to frustrate justice. So those are the views of the victims, although I understand personally that this is a matter for the defense and the prosecution, and I understand the reasons why the prosecution is saying that, and the defense have agreed that the trial should start. But I think it's important that their views in respect of what they feel a speedy trial, because they have been in this condition since the post-election violence, which is about 4 or 5 years, and I think there is a lot of impatience on part of people who are still suffering and living amongst these communities. Thank you for allowing me to put that in. Thank you, Governor.
Thank you very much for your submission, Mr. Chana. Well, as for the disclosure of incriminatory material, the Chamber, of course, after the expert hearing this afternoon, will rule on this issue in a written decision. Now, I would like to turn to another issue with consequences for the trial start date, which is the disclosure of exculpatory material. In this regard, the Chamber notes that the defense for Mr. Ruto has suggested that the prosecution should provide the defense with details of the system it uses to identify potentially exculpatory material. In this regard, the Chamber assumes that all potentially exculpatory information will be disclosed to the defense. The prosecution submits that since the hearing on the confirmation of charges, the prosecution has collected additional materials that may be disclosable pursuant to Article 67(2) and Rule 77, and it is in the process of reviewing them for the purpose of disclosure. May I ask the prosecution, what is the expected time frame for this disclosure?
Your Honours, if I may address you on this point. We have identified some materials to be disclosed pursuant to Article 67(2). There are a number of materials, approximately 120, that we have identified that are ready to be disclosed. Some of these can be disclosed unredacted as soon as practicable. A number of them would require some limited redactions to the names of staff members of the OTP, and some of them would require some more extensive redactions, which may take some more time depending on the redactions and disclosure regime that Your Honours ultimately decide to adopt moving forward. So obviously some of these can happen fairly quickly, but we recognise that identification and disclosure of potentially exculpatory materials is ongoing. So as we review more and more materials, it may be that we identify some information that has to be disclosed, and the time frame on that may take a little bit longer, but certainly we have some amount of materials that we can provide relatively quickly. On the point that Your Honours raised, the defence for Mr. Ruto requesting details of the system that the prosecution uses to identify PEXO, in previous cases we've provided these categories to the defence, and we have no objection to doing so in this instance. Thank you.
Thank you very much. As for time frame, the prosecution said that relatively quickly. Can you be more specific?
Of course. In terms of the materials that can be disclosed unredacted, we could give this easily within the next couple of weeks, if not earlier than that. As I said, any materials that the prosecution determines may require some redactions would depend on the redactions regime that Your Honours adopt and the timing of that. So we're at your convenience.
Thank you very much. Do the defense teams have any outstanding concern as regards to the disclosure of exculpatory material on top of what you have already submitted in writing?
No, Madam President, thank you.
No, pardon, Your Ladyship.
Thank you very much. The Chamber would like to emphasize again that the prosecution must disclose all exculpatory material known to it at this time as soon as possible. Next is reductions proposal. The prosecution has proposed a system for dealing with reductions in its filing 417 at paragraphs 19 to 23, which the Chamber is ready to consider. Just one clarification for this system. May I understand correctly that this new system will not be applied to reductions previously approved by the pretrial chamber, or should it be applied?
Your Honours, we would actually propose that reductions previously applied do fall within the new proposal. We hope that this proposal would certainly streamline, save Your Honours a considerable amount of time and resources, and also provide materials in a much quicker fashion to the defence. And this would also apply in terms of redactions. If Your Honours were minded to consider an inter partes redaction regime such as we've proposed, the lifting of currently applied redactions could also be incorporated into that. And as we noted in our filing, we do consider that the redactions currently applied are still should still be maintained because the circumstances justifying those haven't changed. But of course, as and when those circumstances do change, we would propose that we can lift them and redisclose the materials to the defence, and that could be an inter partes process as well. So it would apply to new redactions, but also to currently existing redactions.
Thank you very much. Okay, the Chamber would like to give the defence teams the opportunity to respond to this prosecution's proposal on reduction regime.
Yes, Madam President, the defence is strongly against this proposal. First of all, we acknowledge the judicial time that chambers